Okay, the next section and the last section of part 2, lawyer's duty as an advocate towards a client, has to do with trial. What happens at trial? All right, first thing to do, the duty of candor to the court, and that has to do with making and correcting false statements. So a lawyer must not make a false statement to the judge or fail to correct a false statement that was previously made. As officers of the court, lawyers must avoid conduct that undermines the integrity of the judicial process. So anytime you can't lie to the judge, and if you've lied to the judge, you told the judge something you thought was true and later find out, whoa, that's not true, you must correct the false statement. Again, that has to do with the duty of candor to the court, correcting false statements. Remember, the duty to remedy false evidence trumps the duty of confidentiality. So anytime there's been a miscarriage of justice or something said to the judge that's not true or any evidence presented that's false, you've got to go and correct it. And that's what we're going to get into in a second when we talk about false evidence. Okay, the next topic here is preserving the integrity of the adjudicative process. That means engaging in wrongful conduct. So during the representation of a client, if the lawyer knows that a person, any person, intends to engage in criminal or fraudulent conduct related to the proceeding, so if you know that one of the defendant's hitmen are going to take out a witness, the lawyer must take remedial measures, including, if necessary, disclosure to the tribunal. That means you must tell the judge, hey, this is going to happen. So this duty applies even if compliance with this rule requires disclosing confidential information. So if you know, if the client tells you that a criminal, let's say the criminal defendant tells the lawyer, hey, I'm going to get that witness wiped out. My hitman's going to do it. You know that witness is supposed to schedule to testify in 2 days. You actually have to say something about that. So once the lawyer knows and actually knows that the client expects assistance permitted, not permitted by the rules. So like, you ask the lawyer like, hey, I expect you to break this law. I expect you to defraud this. I expect you to forge these documents. The lawyer must consult with the client regarding the lawyer's limitation on her conduct. So the lawyer must tell the client, hey, look, I can't do that. I'm bound by the ethical rules, and even though I have to zealously represent you, you can only take whatever lawful and ethical measures are required. So that was the thing about duty to zealously representing clients that we talked about earlier, is that you can't do anything unethical or illegal in the representation of a client. Okay, the next part is offering false evidence. This is a very important part. It gets tested quite often, and for some reason people miss it. So pay close attention to the false evidence part. A lawyer must not knowingly, and that's the key word, must not knowingly offer false evidence. This includes false testimony, as well as falsified documents. The rationale for the rule is that such conduct undermines the integrity of the judicial process. Now, a lawyer may, doesn't have to, but a lawyer may refuse to offer evidence that the lawyer reasonably believes is false. So like, God, I really think this isn't true, but if you don't know, you can still present it. So a lawyer should resolve all doubts about the veracity of the evidence in favor of the client. So if you're sitting there going, I don't believe this, I don't buy this, I don't think the client's story is true, but if you don't know, you should resolve all doubts in favor of the client. So in other words, even if the lawyer believes the evidence is false, the lawyer may still represent the client. The ban against offering false evidence only applies if the lawyer knows the information is false. So again, must not knowingly offer false evidence and must resolve all doubts in favor of the client. Now, what happens when false evidence or false testimony has been introduced? If a lawyer has offered evidence and later comes to know of its falsity, the lawyer must take remedial measures. That means the lawyer must fix it and make it right. So the first step is for the lawyer to speak with the client and explain the lawyer's ethical obligations, especially the lawyer's duty of candor to the court. Like, look, I can't present a falsehood to the court. I can't lie to the judge. I will get in trouble if I do that. So the lawyer should then seek the client's cooperation in correcting the false evidence. Now, if that fails, the lawyer may seek permission to withdraw. But if withdrawal is not permitted or will not undo the effect of the false evidence, the lawyer must disclose enough information to remedy the situation, even if doing so requires the lawyer to reveal confidential information that would otherwise be protected. So if you can't withdraw and if it's seriously adversely affected the proceedings, you've got to do something. You've got to disclose the information, even if you breach the duty of confidentiality, because the duty to prevent false evidence and the duty of candor to the court trumps the duty of confidentiality. So you have a higher duty to the court than you do to your client. Believe that. So in sum, when a lawyer discovers that false evidence has been introduced, the rule actually requires the lawyer to disclose confidential information in order to rectify the matter. A lawyer's duty of candor supersedes the duty of confidentiality. The rationale is that as officers of the court, lawyers must not allow the judge to be misled by false evidence. Okay. In California, there's a little distinction here in California. And we have, so California cannot prevent a criminal defendant from testifying. But you don't have to actually participate in the false testimony. So watch this. Don't forget, if a criminal defendant is going to testify falsely, the ABA says you can't put him on the stand. California says you have to put him on the stand. Because don't forget, one of the client's decision is the client ultimately decides whether or not to testify. So in California, a lawyer may not prevent a criminal defendant from testifying. If the lawyer knows that the defendant intends to testify falsely, the lawyer should persuade the client not to testify. Look, I can't let you get on the stand and go up there and lie. However, if the defendant insists on testifying and the lawyer knows, no keywords knows, that the testimony is false, the lawyer may offer the testimony in a narrative. So go ahead, to criminal defendant, speak and just kind of sit back. The judge knows, the prosecutor knows. Now the jury doesn't necessarily know, but they all know that you're not supporting this purged testimony. Okay, so remember, on the ABA, the lawyer must refuse that testimony. Okay, next thing we have, destroying evidence. Pretty simple rule, can't do it. So a lawyer must not obstruct another party's access to evidence or assist someone else in altering, destroying, or concealing anything that has potential evidentiary value. So I can't tell a potential witness, hey, why don't you burn those documents? Or why don't you get rid of that glove? Or why don't you hide that gun? You can't do that. Okay. And finally, no ex parte communications. What does ex parte means? One-sided. That means it's just you and the judge or just you and one of the jurors. So you cannot have any one-sided communications with the judge and jury. As simple as that. So a lawyer may not communicate ex parte with the judge or juror during the proceedings about the merits of the case. The rule is designed to prevent a lawyer from seeking to influence the judge or members of the jury. That's simple. Don't talk to the judge about the case while it's going on. Don't talk to a juror about the case while it's going on. That's it. We don't want you to influence them. Okay, and that will be a wrap of the entire, not only Section D that deals with trial, but entirely Section 2 that deals with the lawyer's responsibilities and duties as an advocate. And that is all that we got.